responsibilities for upholding human rights from different perspectives. So to cover current practices by governments, stakeholders, civil societies, online platforms in responding to currently prevailing technological challenges. Very, very quickly provide a preface to this is at the moment, I think that there is a growing trend of stakeholders taking a multilateral approach to digital rights or human rights governance in the digital age. And the reason why this is necessary is because quite simply, the traditional model of governance where the government is the only one that has the opportunity to interact with civil society and essentially acquire some insight on what communities on the ground needs is simply not working anymore. Technology presents to us quite a number of unique challenges that require a more concerted effort to protect human rights. And so this is just a general idea as to why we need a multilateral approach in this day and age. So in the slides, there you will also find some information regarding currently existing initiatives that governments, companies, as well as civil society have come up with in order to address these challenges. But then the question becomes, are these initiatives really enough to uphold human rights? And quite simply, the answer is no, because unfortunately, there are several areas of technological development at the moment where we haven't quite found the right formula to balance the competing interests of all those that are involved. And so one of these areas would be related to the enforcement of what we know as the right to be forgotten or the right to erasure. I'm not going to go into too much detail regarding what the right to be forgotten is, but just to make sure that we're on the same page. It's, I think, the most comprehensive definition of the right can be found in the EU's GDPR. It says that the right to be forgotten is essentially the right of data subject or the privilege of data subject to ensure or request data controllers to erase personal data concerning him or her without undue delay. And it is a request that the controller needs to comply with, where the personal data that's being requested to be erased is no longer necessary in relation to the purposes for which they are collected or otherwise processed. I'm going to just quickly put this into the context of ASEAN, because this is the domain in which Manusha Foundation operates. So we monitor the state of digital rights across the Southeast Asian region. So ever since the first recognition of the right to erasure back in 2014, as you can see in the previous, so it started with the Court of Justice of the European Union saying that indeed this right exists. Indeed, people can ask search engines like Google, for instance, to delete their data where it is no longer necessary to be stored. And then it got adopted into a specific provision within the GDPR. And ever since, it's been recognized on a more, on a wider scale, with some Asia Pacific countries already being in on the trend. And in ASEAN at the moment, of the 10 ASEAN countries, 5 already have their own Personal Data Protection Act. Indonesia is the one that very recently got adopted. So not all ASEAN countries, fortunately, have a comprehensive regulatory or legal framework to tackle the issue of privacy. However, let's look at the 5 countries that already have this instrument. based on this table that you can see on the screen, only 3 of these 5 instruments actually make an explicit reference to the right to be forgotten or the right to erasure. And so it's not yet comprehensively or universally recognized across the region yet. Indonesia does include this right. However, there is a difference between recognition and enforcement, because even though the PDPA is now in place, we found that there has been no steps taken to create a mechanism that can be used or resorted to by individuals to request the intervention of the designated personal data authority in the country to have their data removed by data controllers, right? And so this is an issue because even if an individual were to request data controllers for an erasure of their data, if the controller does not comply, there is not a way or a method for the personal data authority to intervene just yet. So this is something that remains to be seen, whether this is something that eventually will be sorted out within the next coming months, because this is a fairly new instrument. We don't know yet. And then there's Thailand as well. Again, it has a specific provision on the right to erasure. However, I guess Thailand's is slightly more concrete than what Indonesia has, in the sense that the failure of data controllers to act under these under the provision can actually be reported to the experts committee on personal data protection. And so Thailand has quite a solid legal basis for this right already in place. And then there's the Philippines. And the Philippines PDPA also provides the National Privacy Commission to intervene or to take action in the case of failure by data controllers to delete data. So this is just the general idea of where we are at today in terms of the right to be forgotten and how we can enforce it in Southeast Asia. However, regardless of the whole recognition and enforcement issue that's rooted within the existence of a legal framework, there are also other challenges, right? So let's say that a country already recognizes the right. Let's say that a country already provides for a mechanism where national data protection authorities can intervene in case of a non-compliance. This doesn't necessarily mean that the right forgotten can ipso facto be enforced easily. So here you can see a list of problems, I suppose, that currently stakeholders are discussing in terms of how we can best make sure that this data can be well enjoyed by everybody. So number one is we don't know exactly how we can empower data subjects to identify and locate personal data items stored on them. So data subjects, they might know that, okay, if I look up my name on Google, so-and-so results would pop up, but then there is no way for certain to identify all of these specific platforms or websites on which my personal data is stored. And so that's an issue, how to best locate, how to best identify where my data is. And then to also ensure that copies of my personal data and the information, whatever information is derived from that data, are well traced. So this is kind of related to the first point. So, let's say that I already know that website A and B store my personal data. How do I know that they haven't made copies of it somewhere that whose existence haven't come to my attention just yet? And then determining also whether a data subject has fulfilled all the criteria to enjoy this right. because as we know, there needs to be a demonstration or proof that the data that's being requested to be removed is no longer necessary for the purposes of the data controller. And then how to best erase the data in question. How do we, in case the right is granted, the court says, okay, we should remove this, the personal data of so-and-so data subject. How do we do so? All the while making sure that not just the data itself, but all of its copies are also properly removed. There's this issue as well regarding, as you can see in this illustration on the right side of the slide, like if, for instance, a data subject has willingly provided information on him or herself to a data controller, and then somebody else, a third party, takes a picture of that information, then can the data subject invoke this right against the person taking the picture? And can the data subject say, hey, I want you to delete that picture that you've taken of my personal information? So is it invocable against that person? And then what happens if the data in question is redistributed? Like I said, this concerns the whole issue of copies of that personal information being created. And then what if the personal information was only memorized by the person? Like there was no picture taken, this person memorized it, and then it copied it manually onto a piece of paper somewhere, for instance. Like, is this also something that can be removed on the basis of the right to be forgotten? So there's all of these questions. It's a matter of determining what the compliance threshold should be in case of enforcement. Basically, what you're seeing here is an excerpt of two court judgments by I think it's the German Supreme Court, wherein it is stated that apparently the right to be forgotten needs to be balanced with the right to, with other human rights, such as the right to access information. Once you've put information on a publicly accessible platform like a website, and then it gets indexed by Google, according to the German court, it should not be as easy for you to say that you want that data removed, because it would concern the right of other people to access that information in exchange. And there is also the problem of freedom of speech and the ease of convenience for tech companies such as Google to also conduct their business, which is, of course, they're in the business of providing information and making sure that information is easily accessible to the general public. And so finding the right balance is also something that we need to zero in on when we try to enforce the right to erasure. So these are examples of how countries in the Asia Pacific region currently regulate this right. Right. So these are screenshots that I've taken from the specific page on Google that allows you to get the answers you need in order to get your data removed. And so Google has provided you with steps basically as to how this is done. And currently it has instated a system in place to do so per European data protection laws. And so there are also other companies which have done so. So for instance, on Meta Workplace, there's also a reference to this right on basically on the same caveat that it would be done according to the GDPR or the EU's legal framework. And then some other ways in which this right has been implemented by tech companies. It doesn't necessarily have to be per request. So automatic deletion of content could also be construed or understood as a way in which tech companies try to implement the right to erasure. So if you have ever used Snapchat, you know that it deletes your whatever pictures or videos you send to your friends after a certain period of time. This is also a method that some tech companies use to safeguard privacy without the need for the data subject to submit a specific request to that company. A similar thing is something that we're all familiar with. Instagram vanish mode. If you send messages to a friend and you turn on vanish mode on Instagram, then the message will get deleted after a while, or after you close that chat, right? And then there are also, right now, apparently there are firms or I guess service providers which specialize in deleting content online. I haven't quite gone into this just yet, but this is something that's very interesting to look into. When we talk about what civil society is most concerned with right now is what the German court, as I've previously explained, has already discussed extensively, which is how do we balance the right to erasure with other human rights, such as the right to access information, the right for businesses to conduct their operations, the right to also the freedom of speech as well. So according to some civil society groups, there's Article 19, the Center for Democracy and Technology, Human Rights Watch, and so on and so forth. There needs to be a system in place that allows deletion not to be implemented on a global basis, right? And so for instance, because right now I live in Indonesia, if I were to ask Google to delete my certain search results based on certain keywords that might reveal my personal information, then Google, according to civil society, Google needs to do that by ensuring that the data will be made completely inaccessible only in Indonesia, not in the entire world. So people that reside in other jurisdictions can still access it. And so this is a way to ensure that balance that I keep mentioning can be achieved. And so there is also, in addition to that, there is also a demand by civil society for governments and courts at the domestic level to publish transparency reports on executed RTBF requests, RTBF being the right to be forgotten. This is a mechanism that ensures that whatever executed RTBF requests there are, the general public can know for sure as to who requested it, the reason why the information was ultimately deleted, the frequency, ensuring that the execution is proportionate, it was necessary, it was well-founded in fact. So whether or not this has been consistently applied in countries that recognize RTBF, that's an interesting question that also I think warrants a separate discussion. So now we're moving on to the next topic, which is, this is again another domain of technological development, which is very much interesting to look at from the human rights lens. The discussion on this focuses on whether it's okay for us to improve the qualities of human beings above normal levels. That's the whole gist of human enhancement. It can either be physical enhancement. For instance, cosmetic surgery is already a very rudimentary form of enhancement. or it could also be, and this is what we call moral enhancement. So it's a way to develop, forms of biomedical interventions to develop the morality of human beings. So can biomedical advances be used to improve someone's morals? And how does that contribute to human development? Can we, for instance, lower someone's serotonin levels to make them a little bit more risk averse, to make them more vigilant of their surroundings? And so the policy debate surrounds whether or not human enhancement should be legitimized, and if people could have the right to avoid technologies being used as a tool to enhance their biological makeup. You will see on this slide the forms of enhancement that are currently in existence, and then the arguments for and against human enhancement, the areas in which enhancements have had some degree of impact, as well as the expected benefits of continuing to explore ways in which people can be enhanced. So the human rights risks, I suppose it's quite clear that when technology starts to intervene with your well-being, or the natural state of your being, then one of the most obvious human rights that can be impacted would be the right to enjoy bodily autonomy, or the right to enjoy mental integrity as well. And then we have the right to life, the right to health. But then also, conversely, there's the right to enjoy the benefits of scientific progress and its applications. This is this is the spectrum of human rights that we need to bear in mind when we try to understand where exactly should governments regulate, and where should what are the bounds in which tech companies or biomedical companies need to operate. So we need to also understand how the short-term benefits of enhancement could outweigh the long-term risks thereof. Right now, you will see a lot of news circulating online about some forms of enhancement already being developed in numerous countries, such as China. There's one in the UK as well by the NHS. They are currently developing some form of artificial blood or synthetic blood that can be infused with health enhancing properties. And then there's also an ongoing debate, I suppose, in the United States to create some kind of pill or medication that people can take in order to increase their ability to understand the importance of respecting COVID-19 related health protocols. The point that I'm trying to make here is that ultimately, all of these discussions point to the simple conclusion that we haven't quite found the right balance yet to uphold human rights in light of the rapidly changing dynamics of technology, right? And there are a lot of interests. There are a lot of difference in opinions that need to be taken into consideration to come up with a proper regulatory framework for this. And the debate is still very much live. Now it's a matter of ensuring that at the center of that debate, and this is also something that Manusha is currently working towards realizing, is the voice of people for whom these regulations, these laws are intended. That's the whole point. The crux of the argument is the same. We have technology. How do we put people at the center of the human rights narrative related to those developments that we are currently seeing? So I suppose that's a good place to end it. I hope that you find it nevertheless useful to cultivate a further discussion on this. Thank you. I'll try my best to answer this because this is very broad. I mean, there are a lot of things that can be done, but one thing for certain is that you can never completely eliminate the possibility of being spied on either by private actors or the government, which is something that Manusha is currently focusing on, the organization that I work for. But I suppose when you're just a regular person using the internet on a daily basis, something to consider is to use tools such as a VPN, maybe, when you're trying to establish connection. A virtual private network has proven to be quite effective in securing your personal information as well as the platforms that you are trying to access. And then also be very mindful of the type of data that you provide when you're signing up for new apps or platforms, etc. In Indonesia, there's been, because I'm Indonesian, so I can only speak for what's happening in the country. What's been happening so far is we've seen a lot of instances of data breach. And usually these data breaches, the data that's leaked to the public was obtained by the hacker from government-owned or government-operated platforms. So for instance, we have a specific app for a government-provided social security scheme. So hundreds of thousands of data points were actually leaked as a result of that. And so I think it goes to show that even on platforms or apps or websites where you think that your personal information would be quite secure, that there's always the risk of that being exposed unbeknownst to you. And aside from that, also be very mindful of, I guess this is quite ironic coming from someone that works towards the democratization of the internet and freedom of speech online. But I do have to say that I think as regular netizens, you need to be very mindful of what you put out on your social media accounts, for instance, what kind of posts you put out, because you will be at a greater risk of being surveilled when you've been included into, I suppose, the government hit list, so to say, if we're talking about government sanctioned surveillance, right? So be very careful of ensuring that you do not put yourself at a heightened risk of being monitored because of your online activities, and that ultimately depends on what you post and what you say on your accounts. Of course, there's the whole debate of, well, freedom of speech, and this is something that civil society organizations such as Manusha is working towards changing, is making the internet a more secure and open space for people to express themselves. But the reality is that at the moment, what you post, what you say on social media will very much determine the likelihood of you being targeted by surveillance operations.